And as you know, you have 30 minutes.
Very good, thank you.
Pardon?
Thank you.
15, I'm sorry.
Your Honor, I don't expect to take the full 15 minutes. Certainly don't need 30, Your Honor. My name is Chris Caffarel. I am here representing Vahid Tabatabai. He was the plaintiff in this matter, as well as he is the appellant. Briefly, may it please the court, briefly go over a few of the key facts in this case. Vahid Tabatabai is an individual who desired to purchase a bar. He was looking in the Lorraine County area, primarily, He found a bar known as the T-Bar in Medina County that he wanted to purchase. He entered into negotiations with Mr. Cliff Ballar and MC Realty. They are the appellees in this matter. They expressed that they were representing owner Mike Thompson. Vahid entered into a contract with Thompson through the representatives under the belief that he was purchasing this T-Bar for approximately $150,000. T-Bar then suffered a catastrophic event where it burned to the ground, and insurance proceeds were received in the amount of $300,000. The contract was clear that the $300,000, even if something had happened to the real estate prior to Mr. Tabatabai taking possession, Mr. Tabatabai would be entitled to any insurance proceeds. Mr. Thompson then said there was no contract, that it was never approved by an attorney, and then attempted to back out of the deal. Vahid then brought suit against Thompson for breach of contract. He also brought suit against Ballar and MC Realty for negligent misrepresentation. The court granted summary judgment for Ballar and MC Realty. Your Honor, two theories of this case. One was that there was a valid contract, and Thompson is liable to Mr. Tabatabai for the $300,000, the amount of that was received from the insurance proceeds. The second was that if there was no valid contract, there should be recovery at least against Ballar and MC Realty for their negligent misrepresentation. Mr. Tabatabai relied upon the representations of MC Realty and Ballar to forego any other realty opportunity that were out there to purchase a bar. The trial court ruled that I'm going to focus on the issue of damages, which the trial court did. The trial court indicated that two things. One, it limited the damages to any out-of-pocket expenses incurred in reliance on that misrepresentation. Secondly, they said that any potential profits from outside opportunities were unclear, so that they were not reliable. This holding is contrary to the law, Your Honor. The law is pretty clear in the McCarthy, Levitt, Crystal, and Heyman Company versus First Union Mortgage. There were genuine issues of fact, just like here, as to whether plaintiff relied upon the representations. Secondly, whether that reliance was justified. The court, in this case, took the position that the prima facie case was made for negligent misrepresentation, so that wasn't an issue in the decision. But the McCarthy court also found that even if there's a slight difference between the benefit of the bargain of damages and the damage that actually incurred in plaintiff's forbearance and pursuing other opportunities, the claim could go forward. So even though it was speculative, the damages, the claim could go forward because of a potential lost opportunity as a result of relying on the misrepresentations. Secondly, similarly, in a case C&R Inc. versus Liberty Mutual Fire Company, there was negligent misrepresentation by a broker. A company relied upon the representation made by this broker in purchasing a lesser amount of insurance, and then instead of getting $1 million policy, they got a $100,000 policy, and when things went awry, they were out the difference. It's the same kind of things that happened here, Your Honor. It didn't matter whether purchasing the higher amount was actually feasible or not. The issue was whether or not that opportunity was there, and whether, in this case, the buyer was not even aware that there were other opportunities. Same thing here. It doesn't matter whether Mr. Tabatabai's purchase of any other property was feasible or not. The issue is whether or not those opportunities were there, and whether or not he missed out by relying on the misrepresentations of the brokers. Here, there actually was a particular testimony as to a piece of property that Mr. Tabatabai did not purchase. Whether feasible or not, he didn't purchase that. It was known to be out there, and as a result, he missed out on that opportunity. So therefore, even if the damages are speculative in nature, the law does allow where a prima facie case for negligent misrepresentation is set forth for those damages to go to the jury. Your Honor, based upon this, I ask you to find that the trial court erred in limiting the damages and find the damages were too speculative to allow the matter to go forward to a jury. Unless you have something, I have nothing else, Your Honors.
Apparently not. Thank you.
Thank you very much for
Have a
your
good
time.
day.